Thank you very much. Well, I certainly feel a certain poignancy in not being state librarian anymore, because if I still were state librarian, which I had the privilege to be from 1994 to 2004, I could now stand up and exempt all of you in honor of this evening of any overdue book fines that you might have in your local library, but I can't do it. I also, in seeing those remarkable exhibits outside, coming into the main dining room here, prepared by the students in the 7th, 8th, 9th grade, feel a slight sense of doubt about my own 40 years and 8 books on California history for Oxford University Press, because I don't think I reached the levels of performance that some of the students have done. It reminds me, I told this story previously, but I'll tell it once again. It reminded me when a couple from San Diego had moved out of California during one of the crises we had in the early 90s financially, and they went up to Idaho. They lived in Idaho for a while. Then they came back to San Diego. They didn't buy their same home, but they bought a home near, in the same block, same area, at a much more dramatic price. I read this interview in the Los Angeles Times recently, and they asked the couple, they said, well, now you went up there and you came back. What motivated you? And the woman said to the reporter, well, she said, you can't get good takeout in Idaho. And I said to myself, that's what I've been trying to say for 40 years and 8 books. And when I look at the concision and the drama, the clarity of presentation of these students' presentations, it's incredibly heartening to me. And I'm deeply honored to be invited to speak this evening before this distinguished organization, especially upon the occasion of its honoring Ron Sugar, with whom I recently had the pleasure of serving on a panel selecting the next president of the University of Southern California, where Mr. Sugar serves with such distinction as a trustee, and where I have the pleasure of being a university professor and professor of history. Now, if I were a lawyer, now that's were, subjunctive case, subjunctive tense rather, if I were a lawyer, which I'm not, although some of my best friends are lawyers, including Jonathan Mandel, whose late mother, Vivian Monroe, founded this organization. If I were a lawyer, I might be tempted, being in the company that I am this evening, of so many attorneys, to discourse on one point or another of the theory of contracts as pertaining to the American Constitution, which functions in part as a contract with and between and among the American people. Likewise, if I were a theologian or an historian of religion, which I am not, I might be tempted to discuss covenants and covenantal theory as pertains most obviously to the religious experience of the Jewish people in ancient times, but also as it passed into Christianity and Islam and exists as well in many of the other great religions of the world, as a contract between the people of God and the Almighty Himself, as a contract, a relationship, a bonding, deriving its vitality from the deepest imperatives, from what Abraham Lincoln described as the mystic chords of memory. Now, were I an historian of England, which I am not, I might be tempted to discuss the Magna Carta and the subsequent conditionings of state power it has engendered down through the centuries, including our own Bill of Rights. Were I a philosopher or an historian of philosophy, I might make a desperate effort to trace, in the brief time allowed me, constitutional theory from Aristotle to Aquinas, from Robert Bellarmine to Thomas Jefferson and the Founding Fathers. But since I am none of these, you shall be free this evening perhaps from such tedious disquisitions, but I am an historian of California, which is to say, I am a citizen of an American Commonwealth that has struggled across the decades for covenant, for contract, for Constitution, for the Bill of Rights, in Native American, Euro-Hispanic, Euro-American, African-American, Asian-American, and now global circumstances. I might even suggest how for nearly a half century I have tried to chronicle in part the efforts of the peoples of California to achieve the benefits of covenantal, contractual, and constitutional relationships. One of the terms used to describe our own age is postmodern. Postmodern is one of those terms that can mean everything, or if not properly applied, can mean not much at all. From the perspective of historical influence, postmodernism suggests that we can intellectually and imaginatively appropriate and internalize past struggles and solutions as part of our own continuing identity. Thus, the polities, meaning the covenants and social arrangements of Native Americans in the pre-European period, are, from a postmodernist perspective, not just the object of anthropological research by non-Native Americans. Indeed, these arrangements have entered into our own legal system, or at the least, they have been recognized by our legal system over the past few decades with dramatic consequences. But this goes deeper than whether or not one band or tribe can build a casino, or stop the desecration of a burial site, or be recompensed for seized property. It means that the 25 to 40 generations of Native American life before the arrival of Europeans engendered polities, sovereignties, social contracts, implied constitutions which remain living entities. For Native Americans, most obviously, but for the rest of us as well. Ask any California youngster with a reasonable primary education who lived in his or her region in times past, and there is a strong chance that thanks to postmodernist instruction, that youngster will tell you about the Chumash, the Tongva, the Maidu, the Ohlone, the Miwok, the Utkemwavi, or whatever peoples live locally and continue to live today in a particular region, and more importantly, how the pattern of their life remains as a living legacy, not just for Native Americans, but for all of us. Likewise, if you look to the laws of the Indies, under which New Spain or Mexico governed California until American annexation, you will find a legacy living in the Hispanic peoples of our state, alive and well since the laws of the Indies were formulated in the early 1570s. These laws were based on the notion that life in the New World, theoretically at least, should be better for ordinary people, to include social and economic betterment, redemption in this world of struggle and work. Based in part on Roman law, which is to say based on the techniques Rome used to develop Iberia, its most successful province 2,000 years ago, the laws of the Indies not only laid out town sites to include Los Angeles in September 1781, but delineated as well social and economic relationships that would protect the people. History must take the ideal with the real, the success with the failure. The laws of the Indies were not universally applied, especially to Native American peoples. At the same time, the governor of California in the Mexican era, a governor by the name of Jose Figueroa, would do his best to integrate Native American peoples into the processes of social justice and self-improvement that the laws of the Indies set forth in the 1570s. Likewise, when Americans came to California in the gold rush, they had a tendency, many of them, to forget their laws of the Indies, which is to say, to forget the American Constitution and Bill of Rights. This was especially true in that epidemic of lynching in the mines in late 1849, early 1850. A later generation would try to upgrade this lynch law as a reprise of old-fashioned Anglo-Saxon justice. But it was not that at all. It was lawlessness, plain and simple. And many of the Americans who were doing it, and certainly the majority of the Americans who witnessed it, felt a sense of shame over what was happening. So too, when Vigilance Committee seized control of San Francisco in 1851 and 1856, tried people in kangaroo courts and hanged them, would a later generation seek to romanticize this as old-fashioned American justice, rather than for what it truly was, a vigilante seizure of the state, lynch law personified. The same thing is true 20 years later in the anti-Chinese riots of the 1870s, inaugurated here in Los Angeles by the lynchings of more than a dozen innocent Chinese victims. One can write an entire history of the frontier era in California in terms of its constitutional abuses, its prohibition against African Americans or Chinese testifying in courts of law, its authorization of the indentured servitude of Native Americans as part of the criminal justice system, its recurrent recourse to lynch law, as late as what happened in the city of San Jose in the early 1930s, and later the incarceration of the feeble and the eccentric in mental hospitals without hearing or due process, the forced sterilization equally without due process under the rubric of eugenics, the de facto segregation continuing into the mid-20th century, the restrictive real estate covenants, the prohibition against Japanese immigrants owning property in their own name, the criminal syndicalism law that made it a felony just to congregate for purposes of political action declared suspect by others, the laws forbidding marriage between whites and peoples of color, the rapacious destruction of the environment through hydraulic mining and other abuses. As I say, one could write the history of California in terms of these abuses, and it has been done and should be done, lest we forget how easy it was for us in the past to lose our way. But if we write this history, because we must, we are also obliged to write the history of how we struggled for corrective action in the face of such abuses. Writing about the gold rush frontier, a native-born Californian, Harvard philosopher and historian Josiah Royce remarked in his seminal History of California, published in the mid-1880s, that in one sense it was not so surprising how so many Americans lost their way, misbehaved in the frontier period, as it was that they were thrown into a vacuum devoid of law and established society. It was rather equally remarkable as to how well so many of them, thrown into this same void of law and established society, how well so many of them behaved, how they struggled to establish social institutions in adverse circumstances, how they met together in the summer of 1849 and drafted a constitution. Not a perfect constitution, mind you. It had to be amended in 1879, but a constitution nevertheless, reflecting the American Constitution as well as the constitutions of the states of New York and Iowa, which guided it. This same California, this California that drafted the Constitution in 1849, reformed it in 1879, this same California, so enmeshed in error and misbehavior as far as the Constitution and Bill of Rights were concerned, was constantly struggling, Royce points out, to correct itself, to discover and create what Royce called the hope of the great community. And in another book, the higher provincialism, meaning loyalty to one's province, in this case California, as the arena in which American law and social ideals could best be found and practiced, sometimes for the first time. Thus, Royce saw the American experience in California as a process of error and correction, guided by constitutional value based in cultural terms, not just in the legal provisions of the Constitution, as crucial as they were, but in a way that the Constitution served as a kind of continuing expression of covenant between the American people in time, in history, and their founding ideals. True, we passed an Alien Land Act, but lawyers came forward to fight it. We passed a Criminal Syndicalism Act, but lawyers did their best to resist it in the courts and eventually prevailed. We seized Japanese American properties during and in the aftermath of World War II, but in the case of Oyama and the state of California, filed in August 1944, a lawyer by the name of Abraham Lincoln Weirin spent the next 4 years fighting it. We segregated the Mendez children into separate and unequal schools in the Westminster School District of Orange County. but a lawyer by the name of David Marcus fought this segregation in court and prevailed in the famous case Mendez versus Westminster. We forbade interracial marriage, but in Perez versus Sharp, a lawyer by the name of Daniel Marshall filed suit on behalf of a Mexican-American and an African-American wishing to marry, and he prevailed. And by the late 1950s, we were even beginning to become constitutional in Sacramento, as evidenced in the UNRRA Civil Rights Act of 1959, which outlawed discrimination in public accommodations a half-decade and more before the Civil Rights Act. And so while I am not a lawyer, I salute these courageous attorneys and all those who have performed and are performing the same tasks. And although I am not a theologian, I do believe that the Constitution and the values the Constitution expresses constitute, pun intended, a covenantal force, a mystic contract at once practical and rooted in human nature, and at the same time animated by the highest of ideals. We have our troubles in California, true, but we have always had our troubles, and we have, most of the time, struggled against our troubles. And we have frequently prevailed against our troubles. How else but through constitutional value could this global commonwealth come to be? This ingathering of the peoples of the planet. This mosaic of languages, cultures, religions, skin tones. Gathered in their chamber in Philadelphia, the Founding Fathers could not have imagined the American societies to be, which the document they were drafting would guide into existence. Or did they? Perhaps they saw it all. Not necessarily as a clear vision of the future, but as justice, law, and fairness set in motion into time, into history, as one would launch a freshly built ship into an unknown sea, confident in the rational arrangements of its crafted and integrated parts, confident of its anchorage in reason and its realistic sense of human nature, both in terms of the tendency of that human nature to lose its way and the hunger of that human nature to sustain a hope for a great and good society, the hope of the great community, as Josiah Royce put it, the hope, this California, this nation of the United States, this America, this Constitution. Thank you so much.